And welcome. Good afternoon, everyone. I'll start again. Good afternoon. I'm Stella Pantazis, president of the Hellenic Law Society, and welcome to the Hellenic Law Society MCLE Symposium presentation of Complying with the Corporate Transparency Act, presented by Jim Patinas, our esteemed Hellenic Law Society board member and counsel with Fox Rothschild. Jim has decades of experience in corporate law, and since we only have 1 hour of time with him, I will turn it over to Jim for his.
Thank you, Stella. Congratulations on or condolences on your ascension to the presidency. Okay, so let's talk about the Corporate Transparency Act, colloquially referred to as the CTA. So it was enacted as part of the budget bill on January 1, 2021, as I recall, over the veto of Trump, then president. I forget why. And this was like a 4,000-page act, and as part of it, there were enhancements to anti-money laundering rules, and the act called the Corporate Transparency Act. It consisted of a few sections. This has been, it was legislation percolating for years at the behest of the intelligence community, because they believe that money launderers, traffickers, drug dealers, criminals in general, were using entities to hide their activities and their money flows. And as you, I'm sure, know, at least before this act, generally you could form an entity and not disclose all the owners. There are exceptions to that, of course. And so the idea is to require entities to disclose their beneficial owners. The business community, in significant part, opposed it, particularly the call it alternative entity community, partnership practitioners, LLC practitioners, as a gross invasion of privacy, but they lost. And they lost in part because the financial community, banks, were also advocates for this approach, have been subject to the Bank Secrecy Act for decades, and they were saying, why does the burden fall on us to disclose certain beneficial owners? As I'm sure you know, by trying to open bank accounts, etc. There's you often are required to disclose personal information. If you've done work in foreign countries, it's even more rigorous. You typically have to disclose things like, a utility bill and things like that. So at least the argument was the rest of the world is ahead of us, so we should catch up. So anyway, this is the act. It was enacted. And it's administered by the Department of Treasury, the Financial Crimes Enforcement Network, referred to as FinCEN. And they were tasked with drafting the rules to implement the act. The act did not become effective until January 1 of this year in terms of its reporting obligations. So we had a couple of years. And so I give you the cite to the act. This is the regulation, which is attached to the slide deck as Annex A, so you can access the act. It's found in 31 Code of Federal Regulations. It's one section, but it has 10 pages of subsections. So it's sort of a slog to work your way through it, but that's the source of the rules. And then the FinCEN has an excellent website. If I were really adept at this, I would take us to the website right now, but then it probably would blow the whole program. But you can easily access it through this link. It's user-friendly. You go to FinCEN, just type FinCEN, and you'll see on the front page beneficial ownership reports. You click on that, and bingo, you've got a page with FAQs, all kinds of links, including links to actually file a report. All reports have to be filed electronically. Can't do them in paper, although you can complete the form as a PDF over time and then submit it electronically. And FinCEN was tasked, these are all filings are confidential. it's not, the level of top secret defense secrets, but apparently one level below. This is an area I'm not familiar with. But so all filings with FinCEN are confidential, whatever that means. Okay, so who has to file? The general assumption here is all entities have to file, and then if you qualify for an exception, you do not have to file. And we'll talk about the exemptions. There are 23 categories of exemptions. So and the filers are called reporting entities. There are two types, domestic and foreign, as outlined on this slide. And what are domestic reporting companies? Well, corporations, limited liability companies, and any other entity created by the filing of a document with the Secretary of State or similar office under the law of a state or Indian tribe. So if you have to file, certificate of corporation, articles of incorporation, certificate of formation, LLCs, articles of organization, LPs, you're a domestic reporting entity, and you will have to file a BRI report unless exempt. If you're and then the second category of reporting entities are foreign reporting companies. These are foreign entities formed under the law of other country, but only if they register to do business in a state. So if you have foreign clients who are not registered in, California, New York, Delaware to do business, they're not deemed a foreign reporting company. They're not subject to the CTA. A lot of us may have clients who, from time to time you say, you really should register in California or Delaware because you're doing business here, and they'll say we don't want to. So the act doesn't, doesn't apply to foreign companies that should register, only foreign companies that actually do register. There's a question about whether LLPs are reporting entities, because that's relevant to law and accounting firms. There's a mixed opinion. Some people believe since an LLP is a general partnership, which of course you don't need to file anything to be a general partnership. An LLP is a general partnership that registers as an LLP, complies with our act, files a document with the Secretary of State. Does that qualify it as a domestic reporting company? There's varying views on that. Some take the position it's not because see, the test is entity created. See this? Created by the filing of a document, and the argument is an LLP is not created by the filing of a Form LLP-1 of the Secretary of State. That just acknowledges the limited liability of its partners. So therefore, it's not an LLP. It's not a reporting entity. Others say, well, better safe than sorry, and assuming it doesn't otherwise qualify for an exemption, file a BOI report. And that's still up in the air. Perhaps FinCEN will publish a frequently asked question on that point. They refer to facts throughout their on the website. There are like 50 of them. They're organized, indexed, pretty accessible and thorough. They're a good source for answering questions that you may have. Okay, so that's okay. So then when are they due?
Jim, what about
yeah.
nonprofit corporations?
Yeah, they unless they're a 501c qualified, and see any of the C's, they're exempt if they're a 501c entity. If they're not, then they are not exempt unless they qualify for one of the other exemptions. Okay, so the act became effective January 1. So let's assume corporate and any entity, reporting company, or foreign that was organized prior to January 1, 2024, and that could be 1910 or 2023. Their reports are due January 1, 2025, so they were given a year to file. For all new entities, so if you form an LLC this year, you have 90 days to file. 90 days for the date of filing. Actually, it's a little more complicated than that, but use the file date as the, day zero. You have 90 days to file, calendar days. The statute said 30 days. They revised it to make it 90 for 2024 only. So next year's 30 days. So if you form an entity this year, you're not exempt. You got to get it in file within 90 days of the filing of the certificate of incorporation. So, okay, so what do these reports contain? There are two categories of information. First, on the reporting company, this slide indicates what you have to disclose as to the reporting company, and it's the full legal name, trade name if different, current address. It's got to be a street address, not a PO box of the company, the state or jurisdiction of the reporting company. It's different for a foreign reporting company. You have to disclose your taxpayer ID or EIN. And if it's foreign, a foreign number. So it's not a lot of information, but this is the category of information you have to include in the BOI report for the reporting company. Okay, now this is the guts of it. So what do you disclose about beneficial owners and company applicants? I'll discuss company applicants in a bit, but for beneficial owners, assuming your clients have they will have beneficial owners, but here's what you disclose for each beneficial owner, and it's not extensive. It's the full legal name, so no abbreviations, not J.D. Vance, it's his full name, whatever it is. A date of birth, a complete street address. I should have said residential here, so it's the complete residential street address of the individual. No PO boxes. If only in the case of companies that are company applicants can you use the commercial address, e.g. CT Corporation, or if you're a law firm that's a company applicant. I'll discuss that in a minute. Then you have to disclose a unique identifying number. This will be either your U.S. passport or your driver's license. These are the details, but essentially those are the two relevant options. And then you have to scan it and include a copy with the BOI report. So that's, again, not a lot of information, but this is it. Full name, date of birth, residence address, your California driver's license or passport, and a copy thereof. Okay. Okay, so beneficial owner, this is where it can get very complex, but essentially there are two categories. And again, beneficial owners can only be individuals. We're not, if it's an entity, you have to go one step up and ask yourself, who are the individuals, persons or individuals who qualify under one of these categories? Either the individual exercises substantial control, heavily defined term, or owns or controls at least 25% of the ownership interests of the reporting company. So if you fall into one of those categories, you're a beneficial owner, the reporting company has to include the information I just went through for each beneficial owner. Substantial control, as you might anticipate, is heavily defined. So they attempt to capture who they're after, namely who's running controlling the company. So one category is a senior officer. Senior officer, if you're a senior officer, you're deemed a beneficial owner, whether you actually exercise control or not. As senior officer on the next page is a defined term. Let's see. Where is it? Yeah, here it is. So senior officers are the president, chief CFO, general counsel, CEO, COO, and any other officer, regardless of official title, who performs similar function. Definition does not include secretary. So anyway, if you're a senior officer, you're a beneficial owner, period. What's a senior officer of an LLC? Well, that definition obviously doesn't apply to an LLC unless, some LLCs adopt the corporate form and their operating agreements literally mimic the bylaws and, provide for the appointment of officers, in which case I think you would follow the rule here as to senior officers. But otherwise, it probably is, well, we can talk about that in a minute. Okay, then the other ones are functional, listed here on slide 8. essentially, if you have appointment authority or authority to determine significant aspects of the governance of the company, which would, so clearly if, say, John Doe, regardless of how many units or shares he or she holds, or it'd be he, has veto power over sales or dissolution, then he has substantial control. You identify him even if he has no shares. But it's a pretty extensive list. Here it is. You can look at it. Amendments to documents. I had a webinar, and a guy who has done something similar. He's a lawyer, and he did it diplomatically, but he also pointed out repeatedly that he's formed a company to assist in the filing of BOI reports. So it's in part an ad, but his position was if members of an LLC have the right to vote, say on dissolution or an amendment to the operating agreement, all of them have substantial control because they have a right to vote upon the one of these aspects. I think that's wrong. I think what this is after is a person who in effect controls that decision, either because he or she has a veto right or they own more than half the membership interests, in which case clearly if dissolution requires a majority vote, they run that determination. We talked about senior officers. And then again, the rule goes on and say you can exercise substantial control through, and there's a list, which of course typically has, or otherwise, but board representation, that's obvious, voting power, rights associated with the financing arrangement. So, if a lender, say if a lender has a right to approve the sale of material assets to the issuer, arguably it would be a beneficial owner. Now that, in my view, that would not apply to, if you, typically a loan won't say that. It'll say if you sell your asset without our consent, the loan is due. And I think that's a commercial term as opposed to clearly ceding control to the lender, although that, depending on the facts, could come out differently. So you can see this can be very broad. And if you have complex, you have an LLC that's heavily negotiated and there are all kinds of voting rights, et cetera, you could spend a lot of time figuring out who's a beneficial owner and who is not. Okay. Okay, this is, well, here I just point out, it can be a complex undertaking. And then the real complexity comes if you lay, in private equity firms or particularly private equity firms or investment firms. They may invest in, numerous portfolio companies, and then the firm itself, the investment fund may have complex structures where they have tiers of owners, including offshore owners, and it can really get ugly to try to figure out who's a beneficial owner. There is, what about directors? My view is if you have a corporation that's, a reporting company, I would identify each of the directors as a beneficial owner because the director, all corporations are managed by or under the supervision of its board of directors, and each has an equal vote. In some Delaware corporations, that can be varied, but and if the board doesn't have an executive committee, in my view, it'd be each director is a beneficial owner. But the FAQs actually state, or maybe it's the rule, but the FAQs state, well, in terms of directors, it's a case-by-case analysis, which is a little weird because family corporations, you could say, the grandfather or the grandmother runs the show and will identify him or her and no one else. Well, okay, that could be facts and circumstances, but in your general small company. It's a difficult decision as to figure out what director should be disclosed and which should not be. And of course, you could offend people if you say we're going to identify A and B but not C because you don't count. Anyway, that's a decision one has to make. Okay, and then the ownership test, 25% or greater. Generally, you have to go up the ladder here. So if say an LLC is the membership interests are owned by 250% members, each a corporation. And then you have to go say, okay, and then look at each corporation and ask yourself, what owners of the corporation own 25% or more of the LLC? And clearly, in my example, if my math is right, someone would have to own 50% or more of one of the corporation members to own 25% or more of the LLC. So you said I could do some math, but if they're tiered structures, figuring out whether an individual passes the ownership test can be complex. Okay, and then they have a special rule about derivatives, options, whatever, and you essentially if a company has outstanding stock options, you have to assume those are exercised and figure out your percentages based on that. So that can really get complicated. Okay, so at this point, your assumption is every entity I form, and this is just to be clear, there's no size test. So if a client says I want to form an LLC with my wife to own, our Russian Hill home, because I don't want our personal name on the records, that LLC will be a domestic reporting entity, and you'll have to file a BOI report for that LLC, even though it has 2 members. So okay, so which are the exemptions? Well, the two major ones, and the annex, the second annex to this slide deck lists each of the 23 from the regs. List each of the 23 exemptions, and you'll see, they're banks, insurance companies, registered broker dealers, things like that. But 2 of the major ones are public companies. So New York Stock Exchange, NASDAQ companies, they're exempt. Partly the theory is, well, they disclose certain owners, like reporting companies have to disclose beneficial owners of 5% or more of their outstanding stock, but they don't have. So that they say that's sufficient. And the defense people would say our concern is not with someone using I don't know NVIDIA to money launder, but the private LLC. So that's and the practical reason is they have political clout, and there's no way they were going to pass legislation that required all reporting companies to file BOI reports. The more important one is large operating companies. This is where your larger clients would qualify for an exemption. So a large operating company has at least 20 full-time employees in the United States. Has to be typo. It should be, and it's so foreign employees don't count. And full-time is described as 30 or more hours a week. It's based on the wage and hour rules. You have to have an operating presence in a physical office in the United States. WeWork doesn't count, or PO box. Has to be a physical office. Has to have filed a federal income tax or information return reporting for the prior year at least $5 million in gross receipts or sales, excluding foreign sourced income. So this has to be U.S. receipts. So 20 or more full-time employees, more than 5 million in domestic gross receipts, and a physical presence. If you meet those tests, you're exempt. You don't have to file anything. This is tricky because if it's a newly organized entity, client, and it'll be a big company, you raised $100 million, is not otherwise exempt. It can't qualify because it hasn't filed federal tax return for the prior year. So it'll have to file a BOI report for its first year. Okay, 20 or more, and you can, let's assume someone's, is there background noise? Someone maybe go on mute. Sorry. Whoop. Okay, got some. The employee test can be tricky because let's assume you got a company that would qualify, but you want to say, well, we have 15 employees and our sister company has 10. We qualify. The FAQs make clear you can't consolidate, aggregate employees across companies. You can aggregate revenues from a parent subsidiary. So if the company has reported, reported 4 million and its subsidiary reported 2 million, and it files a consolidated return, then that should meet the gross receipts test. So this can be tricky, but this would be the exemption that most, long-time companies who are operating companies should have a shot at meeting. In which case you don't have to file anything. You have to file it all. Okay, FinCEN identifier. I didn't talk about company applicants. I should. The company applicants are the people who organize the entity. So if, you're a lawyer, someone says, I want to form an LLC, please do it for me. You get the information. In the old days, you may sign it. The modern practice is to get the client to sign it, but whatever. And then you either file it yourself with the Secretary of State, or you call up CT or one of these outfits and say, file this document right away. Okay, so the company applicant is the person who files or the person who directs the filing of the organizational document. There's nothing to do with the BOI reports. It's the certificate, the organizational document, the articles or the certificate of formation. So if you were involved in that, you're probably a company applicant, in which case you have to file the same information beneficial owners do. Why the hell they want this? Well, I guess if you file a BOI report and you list as one of the beneficial owners, Mark Putin, you may get inquiries from one or more of the feds asking you to tell them more about Mark Putin. And presumably one of the people they'd want to ask are the company applicants, since they were the ones who formed the entity. You don't have to file on more than 2 company applicants. So if, I prepare articles of incorporation, I send them to a service and say, file it. I'm one company applicant. And usually if the company applicant is like CT, the second company applicant would be someone at CT. Okay, so why get FinCEN identifier is the number you get when if you want to file. And since I may be a company applicant and probably will for many entities, I and most lawyers here at the firm have gotten a FinCEN identifier. It was actually not that difficult. It took me 10 minutes. So if I can do it, anyone can do it. You go to that FinCEN website I indicated, and you'll see a link to apply, and off you go. It's all electronic. The only trick is you have to make a copy of your license or passport. I did my license, and be able to upload it, which isn't that difficult. And bingo, you get a FinCEN identifier, which is a number. If you have a FinCEN identifier, and then the reporting company just inserts that number, no name, nothing, just the number. So if I'm a company applicant and I'm the only one under company applicants, they would just, whoever fills out the form would put my number in. What's the benefit of that? Well, assume you have clients that are director of 10 companies that'll have to file BOI reports. That means the 10 entities will have to, disclose the name of your director, a residence address, age, and license number, and a copy. To avoid that, the individual on 10 board just says, "Here's my FinCEN identifier." That way, the only agency that or person that knows his personal information is FinCEN, and it's confidential, at least in theory. So people who are repeaters, who are on a lot of boards or managers of a lot of LLCs, will just get a FinCEN identifier, and they don't have to disclose any personal information to the reporting company. So that's a FinCEN identifier, and it's not that hard to get. Okay, this so then the practice, the most large firms, certainly my firm, have taken the position they do not want to file or prepare BOI reports. No way, no shape. And the reason is, if you file a BOI, well, first of all, even if you filed it, that is, assisted clients in completing the form and pressing the button, you do not want to sign it, because for this reason, someone has to certify the BOI report on behalf of the reporting company, and essentially you're certifying that the report is true, complete, and true, correct, and complete. So that carries, responsibility. And unless, it's a family LLC or something, you really don't, as a lawyer, want to take on that responsibility. And firms don't want to even file, sort of be the clearinghouse for inputting the information of BOI reports, because they don't want to collect their personal information. As I'm sure you all know, hacks are now not uncommon. And if you have personal information of clients that are hacked, you're going to be staring at real problems, including probably liability. Now, it's a little odd for lawyers because, of course, we collect, personal identifying information all the time, particularly if you do estate planning or tax work. But for FinCEN, given and I should have mentioned, FinCEN estimated that the CTA will apply to 32 million entities. So there'll be 32, at least if everyone complies, there'll be 32 million reports filed by January 1, 2025. So to put it mildly, this is by way of comparison, the number of companies traded on the New York Stock Exchange, I think, is less than 10,000. Or substantially less, and we're talking 32 million. The reporting companies will have to file, and then thereafter, now there's no ongoing. You don't file a yearly report, but you do have to file within 30 days any corrections to the reports. And so, someone gets married, someone moves, a beneficial owner moves. You're going to have to file an amended report. The reporting company will, or if you discover any inaccuracy, same rule, 30 days. That's not true for company applicants. I think once you file for them, it's done. But beneficial owners, and I think reporting companies, and of course the gotcha is moving, because it's members' residence address, not business address. And then for complex structures, you could have, more than 10 or more beneficial owners, or even more than that. So that could be a nightmare to monitor compliance. Okay, and then here are the sanctions. So, again, they apply to essentially willful failures, false or fraudulent, information or willful failures. And then you got civil penalties of not more than 500 for each day the violation continues, a fine of not more than 10,000, and/or imprisonment for up to 2 years. FinCEN is made clear they're in the business of assisting people. They're not trying to do gotcha or hammer people, but that's their present position, and of course it's a function of who's in the administration. But anyway, so that's why you don't want to. Under no circumstances do you want to sign a BOI report unless it's a family operation. And so the practice is developed, as I said. Most firms say we're not going to be in the business of filing BOI reports. So everyone's referring them out to CT or whatever, And you may have seen outfits like the lawyer I heard who gave a webinar and then, by the way, pitched his company. You're seeing a lot of that. A lot of them are scams. This firm in Seattle has an outfit called, I think, Fairchild. They like them a lot. They're very responsible. So, and they charge $100 to file a BOI report. I've also had a lot of clients that do it themselves. Once they get used to it, say this is simple. And of course, for most structures, if you have one or two beneficial owners and then a reporting company, it's straightforward, and they say it's a breeze. We did it ourselves, and didn't, for nothing. There's no fee for filing these reports. So the practice has developed that either clients do it themselves or the lawyer assists them, but then says, okay, in terms of actually filing it, call John Doe here at this company, and they'll work with you on completing the report. And in that instance, what happens is people get the PDF off the website, complete it in stages or at once, and sign it, and then file it in a Dropbox maintained by the service company. And then they just take the Dropbox information and make the actual filing for you. And, in a fair charge case, charge $100 and off you go. Okay. Okay. I wanted now. Here's a problem. So in my, I've had cases where you have complex structures and you have, foreign entities that arguably are beneficial owners. So what if the foreign entity, a Swiss guy, says, I'm not going to disclose to you my passport, or I'm not going to give you my residence address because I don't care what you say about its confidentiality. I'm not going to do that. So how do you file a BOI report if you're, the secretary of the company or the CFO, where you've got a beneficial owner who refuses to cooperate? Because you have to, you CFO have to certify the report as true, accurate, and complete, and you got a deadline. The FinCEN sort of acknowledged this when in one of their initial releases, and they actually had an option on the form that says unknown, where you could check the unknown box, and they made clear that would not excuse you from completing the form, but you could file it and certify to it because you had an unknown box. Well, they got such negative comment because I remember one person commented and says, if you do this, here's the form of report you're all going to get. And she actually attached the form of the report with every box checked unknown. And so in the final form of report, Fin said, whoops, okay, we're not going to do that. We're going to study it. And maybe I'll offer that option at a later date. Well, they haven't done it yet. So that can be a real problem if you've got, got a company or a client who says, I can't get John Doe to give me the information. He refuses. What do I do? And there isn't a box, as I recall. I haven't actually made a filing myself, where you have explanation. Where you could say, hey, I'm doing my best, but I can't. And of course, the beneficial owner who absolutely refuses to supply information, himself or herself could be subject to penalties, but and hopefully in most cases you can talk them into it. But that can be a problem. Okay, so and then here are the annexes. Here's the actual reg. Sorry for the small font. You can see, have fun with that. And then the second annex. These are all the exemptions. So you can see, what the government authority, banks, credit unions, securities exchange, investment company, registered investment companies or registered investment advisors, certain venture capital. If you represent funds, you really have to spend time figuring out this rule. And a bunch of Wall Street firms published a memo, like 20 pages, which I have, which addresses solely the obligation of investment funds and their advisors to file CTA reports. It's very helpful. So the more here are the tax exempt entities. So one kicker here is condos are not exempt because they're not. Peter knows this better than I do. They're not a 501c entity. They're a 501 something else. And so unless the condo qualifies as a large operating company, which would be unusual, condos have to file. I mean, I'm in a condo, and we're gonna have to file by the end of the year. It's just I'm sure the board of directors is not going to be happy about that. So anyway, so that's it, folks. Any questions?
Jim,
Sir?
if you have a 501c California nonprofit corporation that temporarily loses its exemption because they don't file their informational tax returns, or for some reason they're suspended by the Secretary of State, that kind of thing, would a temporary loss require them to register with FinCEN?
Yeah, I don't know, Peter. I mean, the definition is assuming it throughout the period you talked about, they remain a 501c3 or whatever. They don't lose that. That's not in jeopardy.
Well, they would if they don't file informational tax returns like a 990, some form of a 990N or EZ or a 990 full form for 3 years in a row. Then they do lose their tax exempt status, and then they have to apply to reinstate it retroactively. So,
well, I think, yeah. First of all, you should look at the facts, FAQs, to see if they address this. But I would think as long as they're a 501c3, until it's lost or revoked or whatever happens, they still should qualify. But don't rely on that.
and would an unincorporated association be covered by this at all?
No, for the same reason general partnerships are not covered. Even
Okay.
if the partnership voluntarily files a Form GP1 statement of partnership.
Okay.
So even if you file, simple LLCs, you're going to have to at least advise a client, hey, you're going to need to file a BOI report, and here's a firm that can help you. Assuming you don't want to do it, and in no circumstances should you. Well, you shouldn't sign the report. I don't. I'm not. I understand the position my and other firms have taken. They do not want to collect personal information because of fear of being hacked. But I don't. As long as the client certifies it, I don't. Whatever. Certainly, anyone under the age of fill in the blank will quickly figure out how to do this on FinCEN's website. It's folks of my age that are just a challenge.
Hey, Jim, this is Mike Casolas.
Uh-huh.
Can I ask a question?
Yeah, sure, of course.
Couple things. What about trusts? You may have covered this. I'm a trustee for many different trusts, people alive and people not alive, court appointed, etc. Are there any requirements that the trustee may have to file these things on behalf of entities and/or individuals?
Well, first of all, a trust isn't an entity organized by filing with the Secretary of State, so it's not a reporting company.
So
But
that's the
but there are complicated questions about trusts being beneficial owners. So if you have if a trust owns 25% or more of the stock of a corporation, and the corporation's not exempt, then yeah, it'll be a beneficial owner, and information about the trust will have to be included in the report, including the name of the trustees and their information, and then any beneficiaries of 50% or more of the corpus. There are precise rules on how you report on trusts as beneficial owners. They're in the regs. And I'm sure there are FAQs also that address that specifically on the FinCEN's website.
I have two more too. Thanks. So that real quick. So comment on that is it's basically if the entity is organized through the Secretary of State, then they fall into the bucket. It sounds like. Is that correct?
Yeah, that's the general rule. Yes.
So then I also serve as a receiver over corporations and other entities. Whose responsibility is it to report on behalf of an entity that's in a state court receivership, let's just say, or entities? What do you think it would be, the receiver, or it would be the beneficial owners, both?
Yeah, I would think the receiver initially. I mean, it's in effect the CEO, right?
Essentially, yes.
Yeah, I would think, or if you have a CFO or whatever, foisted on him or her. But the fact that there is no longer an dissolution exemption, but that's complicated, and it sounds like you haven't wound up, so you're still in business. I don't think there's an exemption for companies and entities in receivership if they otherwise qualify as a reporting entity, formed. Well, when was the corporation organized?
What's that?
When was the corporation as
It
to
was,
which
it was organized before the receivership. These entities, this entity I'm specifically, there's several entities, but they were all organized before the state court receivership in California and Nevada,
and they were organized prior to January 1, 2024?
Yes, I'm sorry. Yes.
Okay, so you got to the end of the year to file.
Right. Then I'm sorry. What about bankruptcy estates? I'm not sure if you know this, but I mean, I've got cases where I'm the Chapter 11 trustee or the liquidating trustee, and we're winding down these organizations, but they're entities. Is there an exemption there for those kinds of entities, or?
I don't think so, but you need to either we'll talk offline, or you need to walk through the list of exemptions attached as the second annex to the slide deck, just to see if any of them jump out at you.
Okay, real good. There was one more, but I can't remember what it was. I went through a lot of them there, so thank you. I really appreciate it. Oh, I know. I'm sorry. I do remember. I'm sorry. So with regards to beneficial owners, so I have another situation where I'm managing multiple LLCs for a trust, and the trust or the trustee is a bank. And the bank, as the trustee, they have the trust has a beneficial interest in all these entities that I'm managing. So if I'm not sure if the bank is exempt or not, they're trying to work that out themselves, but if they do file, then is there also a filing requirement on behalf of the entity itself, even though the beneficial owners are reporting their beneficial interest?
Well, first of all, beneficial owners don't directly report anything, so it's an entity obligation. So you say the entities are in bankruptcy, or what are they?
No, they're not in bankruptcy. They're just
okay.
This is an estate for a decedent.
Yeah. No, I think unless they're otherwise exempt, large operating companies, and the fact that the bank is exempt as a bank doesn't exempt the entity with respect to which the bank is serving in some function. So you got to look at that entity by entity. Yeah, I think you may have to file.
And then any thought? So then you talked about real quick about getting one FinCEN number.
Right.
So it looks like I probably got to file like there's tons of these things. Do you file under one number, or does each entity have its own number?
Well, the entities have, they'll get numbers, but you as a beneficial owner, because you're a senior officer or whatever, controlling person, receiver, you once you get a FinCEN number, that's the number used, even if you sit on 10,000 boards,
Right.
same number.
Yeah, and I'm not an owner, I'm not an owner in any of these organizations. I'm just, I'm running them, and because there's absentee owners for many.
Right, but under the substantial control test, you may be deemed a beneficial owner.
Oh, okay.
Yeah, yeah. The senior officer is a beneficial owner of a corporation, even if, like a president or a CEO, even if they own no shares.
Great. Thank you so much. I know those are kind of obscure questions, but I appreciate it. Thank you.
Jim, I have some basic questions, not obscure ones, Mike. When you were talking about condos, what we're talking about is an HOA, the homeowners association. And this is yet another reason never to be on an HOA board as a lawyer, because they're the entity that has to file, right? The HOA.
Well, let me be clear here. If it's an unincorporated association, it's not a reporting entity. So most condos now are, nonprofit, mutual benefit, nonprofit corporations. So for them, since they're not a 501c entity, and again, Peter's the expert, they don't qualify for that exemption unless they're a large operating company or some other exemption. They have to file. And question is, who are the controlling entities? And in my instance, I'm president of our condo. It's pretty clear, and we have 15 unit owners, so no one has a greater than, what did I say, 25% interest. So I think we're going to have to just report on each of the directors and the senior officers. To be clear, FinCEN has emphasized this. You're talking 32 million companies. I'd say 99.99% of the filers. There should be zero interest in these people vis-a-vis, money launderers, you name it. I mean, there's a real argument on a cost-benefit analysis. The thing is a joke. When they adopted it, they have to have a cost-benefit analysis, which usually is the last 300 pages of the release. And I think at one point they said, we calculate the average cost of filing these things like $42. I forget the exact number, but it was like pathetic. You got to be kidding me. It's just no way if for any structure that's, So to your point, the vast majority of information they get is going to be, of no use, of no law enforcement use, zero. And it's of course supposed to be made in, strict confidence. They emphasize it over and over.
But the FBI can see it.
Well, yeah, all IRS can see it. Foreign state and local agencies can see it if they get a court order. Foreign enforcement agencies can see it if they get a court order. So, if one's a cynic, you could say, yeah, right. But on the other hand, you don't disclose your social security number. Between the two, I did the California license number. I figure that's less sensitive than passport number, but who knows? And of course, you have to file a photo.
My second question is, is there anybody that has to file before January 1, 2025? Is everybody protected until that date?
No, as I said, if you organize a new entity after January 1, 2024, you have 90 days to file from the date of filing. So if you've been organizing any entities this year, you have 90 days from the date of filing. Next year, that rule is 30 days. So, again, for the 32 million entities that were in existence as of January 1, 2024, they have a year. But any new entity, you have 90 days, and beginning next year and thereafter, you have 30 days from date of filing. And again, to repeat, you got 30 days to file amended reports if any of the information in the initial report is, becomes inaccurate.
Hey, Jim, on the issue of beneficial owners, I've had a few clients over my 40 years that have come in and said, I want to be a nonprofit corporation, operate on a not-for-profit basis. but still dedicate their assets to charitable or civic social welfare purposes that would normally fall under 501c3 or 4. So in that situation, the directors of the corporation are not beneficial owners of the assets, which are dedicated, say, to charitable purposes. So how does that equate or fit into this
Makes sense.
formula?
Well,
this
if it's a 501c3, it's exempt. It doesn't report.
No, it's not. It could be a not-for-profit corporation that does not file for tax exemption.
Huh. Well, then you're in the soup. I don't.
Yeah. Well, but they're not, the directors would not be beneficial owners because they would still be operating for, say, charitable purposes, but paying a minimum tax every year and working out their income and deductions, however they.
So who makes the decisions vis-a-vis the business? Is it the board?
Well, it's not a business. It's a charitable activity operated on a not-for-profit basis. So the board controls it, but the assets are dedicated to charity. On dissolution, they would give the money, say, to a 501c3. So there's no benefit.
Yeah. Well, there's the. Yeah, I don't. I mean, I guess the question is who's running the show. If it's like a, if they never meet and make decisions, you could say they're no one exercises the potential control because it's really not an operating business. I don't know, but so you would say there are no beneficial owners?
Well, I mean, I would take the position that they don't own the assets, so therefore they can't be beneficial owners. They're not entitled to take the assets.
Well, remember, a corporation doesn't have to own assets. So if you form a nonprofit has no assets, there's no exemption for inactive entities unless they're kaput, they're dissolved, canceled. So it's like my LLC. You have a husband and wife who buy a home and put it in an LLC. It's not a business. But they're not exempt. They got to file. They're not running a business. They just own a home at Tahoe.
Yeah, there's also, you mentioned these other entities, like there's a 528 organization of owners that are nonprofit that can incorporate, and then they can operate a common facility for the beneficial enjoyment of the owners, like a group of owners in an area that want to operate a swimming pool for everybody. That would qualify under 528. They wouldn't be a 501c organization.
Yeah. So I think you're in the soup again, unless, again, look, just walk through the list of exemptions in the back, Peter, make sure there's no separate, I don't think so, but like I say, there are 23 categories of exemptions. So you just want to thumb through that, make sure nothing jumps out at you. Okay, it's 6 o'clock. So the bewitching hour. Anyone else?
How do we get copies of the written materials?
Stuart, it's in the link. So he distributed a reminder, and if you click on the link, you can get a copy of the slide deck with its annexes.
And how do we get the certificate of attendance?
The Stuart or Stella will, or Peter will.
There's a link right here. If you go to this link in the chat box, the presentation is linked towards the bottom there. There's a button called download presentation.
Oh, great.
Oh, what?
Or you
Can
can
I ask a
go
question?
directly to this link. This link goes directly to it.
And the MCLE certificate, Stuart? You'll be sending that
The
separately.
MCLE certificate is will be submitted on your behalf. There's no longer a individual form that you have to sign. I basically take attendance and then make sure everybody's bar number is accurate and then submit that on your behalf. So there's a new system that allows those.